If you love liberty, declare your independence by signing the Shire Society Declaration at shiresociety.com.
So the first House bill that we're hearing this morning is House Bill 249. I have a number of people who have signed up for this. And the first speaker that I'll be recognizing is the sponsor of the bill, Representative Valancourt, please. Thank you. And I will say that Representative Valancourt wanted to pass out a copy of a court decision which he has given me, and I'm going to pass that out to members as he speaks. I understand there's also written material that we'll be getting that we'll be receiving also. Representative Valancourt, thank you.
Thank you very much, members of the Election Law Committee. My name is Steve Valancourt. I represent Manchester Ward 8, home of the airport. I'm in my 10th term. However, I wasn't here last term, so I've had a little hiatus. And as I did serve 2 or 3 terms on election law way back the turn of the century. I don't recognize a lot of faces here, so a lot of you are new. And this issue confronted in this bill has a bit of a history. I am passing out the United States Court of Appeals First Circuit decision on the selfie issue. So while it has a long history, it's only 21 or 22 pages, this ruling. And for me, it's one of the easier rulings to understand in legalese that I've ever done. And I think the reason it's so easy to understand is because the proposition is so absurd. The idea that you cannot take a picture of your own vote in the voting booth and post it online, to me it's mind-boggling. I wasn't on the Election Law Committee 2 terms ago when this bill passed, but I was on criminal justice. And it went to criminal justice as the second committee, in other words, to determine the penalty and that. The fact that we're going to fine someone $1,000, what's next, a death penalty for taking a picture of your vote? I am in a bit of a problem area because of all the people that I've known here in Concord for the last 20 years, without a doubt, the one I respect most, always have, and still do, is Secretary of State Bill Gardner. And he and I passionately disagree on this issue. He will fight for the right to ban you from taking a picture of your ballot until he gets to the Supreme Court, if he can get there. As I poked my head in earlier, I did see that somebody sitting at this table was talking about this bill. So you can see it's been in the news. In fact, I think when I was watching the Trump v. Clinton focus this past fall, this matter came up because it was decided in the court then that the ban on selfies is unconstitutional. And if you'll read this ruling, it's not even a close call. In fact, at one point, they say banning selfies is like burning down the house to save the pig. I didn't know about this bill when it was first passed. The first time I got aware of it was when it came to criminal justice. And amazingly, the decision, if you read it, refers to what happened in Criminal Justice Committee. Because one of the attempts I made as a member of Criminal Justice was to focus on this bill so it wouldn't be so overpoweringly awesome against everybody in the world, everybody in the United States. And as the justices wrote in this decision, that effort by me was defeated. What my amendment would have said was, it shall be illegal to take a selfie if the purpose is to gain monetary reward. Because Secretary Gardner passionately feels that this, allowing people to take selfies, will lead to them selling their vote so that they can show the selfie as proof that they took it. Now, to me that makes no sense. In fact, the court rules that there is no evidence of that. To me, because how could you enforce this bill? If you take a selfie, you're a young kid, most I see would be young people taking this, out of their exuberance to show that they voted. If you take a selfie, nobody's going to be in the voting booth with you knowing that you've done this. That would be illegal. That would in fact violate the sanctity of the voting booth. So the only way you can possibly be caught taking a selfie is if you turn yourself in. So again, as this ruling says, this makes everybody guilty except those who really are guilty. The innocent, it assumes we're all guilty. because anybody can take a selfie. That's much too broad a focus for the court to have allowed it to stand. But frankly, I would have filed this anyway, because to me it doesn't make sense that you not be allowed to do this. We're in the 21st century. I mean, I understand the Secretary of State, my good friend, likes to quote Madison and Jefferson. I think they'd be on my side on this one, because this bill does not force you to take a selfie. Nothing says you have to. In fact, had the bill not passed, I don't think anybody would have been taking selfies. It basically only happened as a protest because somebody, I think Representative Horgan is here, got the idea that he passed this a couple of terms ago. As I was walking through the lobby of the State House yesterday, I had just spoken with Secretary Gardner, I saw all these kids. I think they were probably on a tour of the State House, but they all had cameras, and they were all taking pictures of the lobby of of the State House. Some of them were taking selfies of the lobby. Now, are we going to pass a law saying nobody shall be allowed to take a photo inside the State House because that could be used to show where to set up a bomb or something? That's how absurd this bill is. It is a solution in search of a problem. There is no problem with people selling their votes, but don't believe me, you can read the decision because the decision goes into it in great detail. And it's quite easy to read. It also gives the history of the bill and what we attempt to do in criminal justice. To me, I'm just basically at mine's end. As I say, I wasn't elected 2 years ago, but I promised myself, if you're ever elected again, the first thing you should do is file this bill to get rid of this. One thing, it's already been declared unconstitutional in 2 courts. As the lady sitting here an hour ago might have told you, it's still going on, but the chances are it's not ever going to be passed. So it is illegal, and we should not have bills on our statutes that are illegal. And anyway, it's not a good idea. We should be encouraging young people to take pride in voting, and I think taking a selfie of your ballot is doing that.
Thank you, representatives. Do members of the committee have questions for the representative at this time? I'm not seeing any. Thank you for your testimony.
Thank you.
I also have signed up to speak in favor of the bill. Representative Pohl, who is a co-sponsor of the bill. Thank you.
Thank you, Madam Chair. Representative Pohl, serving the towns of Bow and Dunbarton, also known as Merrimack 23. I believe, and I was looking back to see the bill was filed last year as well. This is not the first time I have sponsored this bill to repeal this. If someone were to go looking around on various social media sites, you'll see a picture of a ballot. My face isn't on it, but I took a picture of the ballot. Right? Coercion of a voter intent is already in the statutes under 639. I think it was 37. Okay, you can't force someone, okay, through either financial means because you want to reward them on how they vote, or through some other threat of violence, okay, to vote a certain way. That is currently illegal and always has been. If we believe that law is inadequate, then fix it. But prohibiting someone from expressing how they have voted or how they feel about something is clearly a First Amendment violation. And with that, I will end my testimony asking that you repeal a law that 2 courts and a number of others have already found unconstitutional. If you feel that we need to address the issue of coercion of voting, which is the concern, then we should fix that statute.
Thank you. I'm sorry, did anybody have any questions for the representatives before? Thank you.
No.
Darryl Perry has signed up to speak for this bill. And Darryl, nice to see you, Mr. Perry, again.
Good to see you again.
Mr. Perry, I will note that you have spoken to speak twice on House Bill 218. Did you mean one of these to be for 253?
Yes, I did.
Thank you. I just wanted to clarify that before I forgot.
Yeah, temporary dyslexia, I guess. For the record, Darryl Perry, CEO of Liberty Lobby LLC. This is, I believe, the 4th time I've been before this committee on this exact subject. The ACLU's been here numerous times. And as was mentioned earlier, the First Circuit Court of Appeals has deemed this to be unconstitutional. And if you permit me to read a very brief excerpt from that ruling, where they ruled digital photography, the internet, and social media are not unknown quantities
They've been ubiquitous for several election cycles without being shown to have the effect of furthering vote buying or voter intimidation. Skipping down, Secretary Gardner has admitted that New Hampshire has not received any complaints of vote buying during his term as Secretary of State and can only point to incidents of vote buying happening in the 19th century, well over 120 years ago. So the argument that ballot selfies encourages vote buying is completely debunked. The next claim is that prohibiting the ballot selfie is protecting the secret ballot. Well, as was mentioned, no one is being forced to take a ballot selfie, and the court further rules that the law controls the use of imagery of marked ballots, regardless of when, where, or how the imagery is publicized, adding that the prohibition is curtail on the freedom of speech of all voters, not just those motivated for an illegal reason. And as was mentioned, it's not just the First Circuit that has thrown this out. A good friend of mine was actually the plaintiff in a case in Colorado. She's the outreach coordinator for the Libertarian Party of Colorado. They have a similar statute on their books. She wanted to make a how-to vote video. And she was informed that if you make a video showing someone how to fill out a ballot, you are in violation of the prohibition on, and allow me to read the language because it's the exact same. No voter shall allow his or her ballot to be seen by any person with the intent of letting it known how he or she is going to vote. So by filling out a sample ballot, it was construed that that was a violation of the ballot selfie law. She filed an injunction or a court action on with the ACLU in Colorado. Colorado court threw it out. She was allowed to make the how to fill out a ballot video. So if this does proceed any further through the courts, then it's most likely going to be thrown out at the Supreme Court level as well. And I know that on at least 2 occasions of the 3 previous hearings of this bill, the committee report said something along the lines of, the committee believes that the law should not be changed prior to the conclusion of the court action. And if I understand correctly, the state wants to possibly pursue this to the Supreme Court. So court action is not yet concluded. But I would still recommend ought to pass on HB 249, and I can email the committee my notes here.
Thank you. Any questions? Representative Porter.
Thank you, Madam Chair. Thank you for taking my question. It's been stated several times during this testimony that no one is being forced to take a ballot selfie. I'm wondering how you know that.
Well, if someone is being forced, that would be voter intimidation, and that's already illegal. But the statute here does not require anyone. So when I talk about force, I'm saying from the legislature or from the government. So nobody, as far as government penalties, there is no government penalty for not taking a ballot selfie. So if HB 249 goes through, there's not all of a sudden going to be a state law that says everyone who votes must take a picture of their ballot. But if someone is being forced to go vote and take a picture to prove it, well, that's voter intimidation, vote buying, that's already illegal. At one time in this country, it was a common occurrence for people to be plied with alcohol and taken around from polling place to polling place. And there are some states that still have provisions that liquor stores have to be closed on election day to prevent that practice. It's believed that Edgar Allan Poe was actually a victim of that because they found him drunk and disheveled when he was dying. So they believe that he was being plied with alcohol and taken from polling place to polling place. So I agree with the previous speaker. This is a solution in search of a problem.
Thank you. Other questions from committee members? I'm seeing none. Thank you for your testimony here. I also have signed up to speak in favor of the bill with written testimony, Attorney Bissonnette from the ACLU.
Thank you, Madam Chair. If you have written testimony, I'll circulate here. My name is Gilles Bissonette. I'm the legal director for the American Civil Liberties Union of New Hampshire. We're in support of HB 249. I'm actually the attorney that litigated this case, the quote Ballot Selfie case that was decided at the district court level here in Concord, as well as before the First Circuit in Boston. In most of those instances, the law was struck down, and I think it's certainly, I think the First Circuit decision is worth reading. The court there felt very strongly that this type of law violated free speech protections under the First Amendment, going so far as to saying in footnote 6 that this law is antithetical to democratic values. And I think the reason that the court felt so strongly that this law was problematic is because even if we were to assume, that voter coercion and voter fraud are an issue in the photographic display of marked ballots, and there's no evidence to suggest that this is an issue, by the way, the law still is tremendously overbroad because it sweeps within its scope not just instances of voter coercion, not just instances of voter fraud, which are already illegal under existing law, but it goes far beyond that and sweeps within its scope innocent political speech. The speech, for example, of an 18-year-old newly minted voter who's excited about having voted in her first election and wants to engage in political speech using the powerful imagery of a marked ballot on social media. So that's really why the court felt as strongly as it did. My written testimony summarizes the decision with page citations to the opinion. I think it is true, I think as Attorney Edwards mentioned before, as have some people who spoke before me, that the state has filed a Supreme Court petition before the U.S. Supreme Court. That was filed, I believe, right after Christmas, maybe December 26th, 27th. We, on behalf of the plaintiffs in the case, have 60 days to respond, and then after that, the court will make a decision whether to take the case or not. I would note that it's exceptionally unlikely that this court will take the case. And I frankly think that's because the unconstitutionality of the law is so clear. And that's also why we would recommend, or we would ask the committee to repeal this law. We think going through the cert process would just really amount to a waste of judicial resources. Just a few other points, and I'll rest on my testimony. I know there's a long list of speakers, but several other courts have struck down similar laws. Indiana, Colorado have gone down that path. I would note that in those decisions, the law was preliminarily enjoined, so the merits of those cases are still actually currently being litigated in those courts. And I would also note that the national trend really is to eliminate, not expand restrictions on the ability of individuals to electronically convey through imagery how they voted. And I think that's in recognition of the fact that we're in the internet age and that this speech to a lot of people is tremendously powerful. A few examples: Maine, Oregon, Utah, California, and Arizona have recently repealed similar ballot selfie bans that were on the books. And so that's for those reasons as well, we would recommend that this bill be out to pass. One last note that I just wanted to mention, that I think we would of course be perfectly fine if the poster language in section 5 and 6 was kept in. I mean, there's no objection to that. I think the poster is in fact a prudent measure. So the repeal language that we're focusing on is exclusively in section 1 of the bill. But thank you so much for the committee.
Thank you. Questions, Representative Harrington?
Yeah. Thank you, Madam Chair. Thank you for taking my question. I'm looking at this and I'm trying to figure out if, they print sample ballots in the newspapers all the time, or other places you can get it. So if I were to take a sample ballot that was identical to the one I filled out at the polls, marked it the same way I did on the actual ballot at the polls, scanned it in and posted it on some website, would that be illegal under this? Because it wasn't the actual ballot, but something that looked like the actual ballot?
Yeah, I mean, I think it's a great question, Representative. I don't have a great answer to that. When you look at the existing language, what is banned is displaying imagery of how you have voted, past tense. So arguably in that case, that ballot was not cast, so it's not necessarily a reflection of how you have voted, but maybe it could be construed that way. I'm not as familiar with the Colorado case. I know there was a suggestion before that the Colorado statute was construed that way. So I don't have a great answer to your question.
Follow up, please. But let's take it even further then. Let's say I don't use any type of a sample ballot. Let's just say I get on a internet list, email list, and I say, hey, everybody, I want you to know how I voted. And then I write down each office and who I voted for. Would that be illegal?
No, of course not. And in fact, one of the arguments that the state's made in our case is that this law is appropriate because there are all of these alternative channels of communicating how you voted. But that's really not how the First Amendment analysis works. The state doesn't really get to pick and choose how a speaker communicates his or her message. The speaker gets to decide that, absent a compelling governmental interest in tailoring. And here the problem with the law is what lawyers call tailoring, is that the law far exceeds what it aims to address, which is vote buying and voter coercion, because it sweeps within its scope innocent speech that people find very powerful. I think there's a reason people are taking photographs of their ballots and posting it, because they think it really conveys a compelling message.
Thank you.
Thank you, Representative Pearson.
Thank you, Madam Chair. This is a question for the more benign language of the bill that Attorney Bissonnette just brought up. So maybe it's actually better for Representative Valancourt to answer, but I want to know what the purpose behind striking lines 14 through 18 was.
I think I can explain, but
I suspect the speaker is able to address that.
yes, Representative Valancourt could correct me if I'm wrong, but the HB, this is about repealing HB 366, which was the bill back in 2014. That bill included all of this language. It added the poster language as well. And so I suspect what happened through OLS is that the request was just repeal the whole thing, but that only a component really dealt with ballot selfies. But I can stand corrected if Representative Valancourt disagrees.
I'm seeing a representation that was correct from Representative Valancourt. Thank you. Any other questions from committee members? I'm seeing none.
Thank you, Madam Chair.
Thank you. Representative Hines, speaking in favor of the bill.
Thank you. I recommend that this bill pass. Ballot selfie law prohibiting that is voter suppression. So some people, you have a First Amendment right to vote, you have a First Amendment right to speak. If we're making someone choose that, how do we know which way they're going to go? I personally won't give up either right. I take my ballot selfie, I post it, I make it well known. I testified last time this law, I expect it was unconstitutional. 2 courts have agreed with me, so yay for that. But hopefully, I mean, as it is, this law is unconstitutional. And by keeping it, you're requiring people to either break the law or not vote. And I suggest that that's the wrong way to go about it. We want to encourage people to vote, and if people want to express how they vote to other people, I think they should have that right. Yes?
Thank you, Representative. Question.
Thank you, Madam Chair. You earlier in your statement said that you believe that it's voter suppression?
Yeah, I believe it's voter suppression because you're telling people you can vote, but you can't tell people, and if you do tell people, you're going to break the law. And a lot of people, I suggest, don't want to break the law when they're going to vote, and they're having to choose among these 2 rights to give up, and they might say, well, I'm just not going to vote because I want to tell people. So I suggest that it is encouraging certain people just not to vote.
Thank you.
Thank you. Thank you.
Any questions, other questions for the representative? Seeing none, Representative Corrigan.
Okay, thank you very much, Madam Chair. My name is Representative Timothy Horgan. I represent Stratford County District 6, which is the town's term of Madbury, and I was the prime sponsor of the bill HB 366, which was passed in 2014, although the language that was actually passed by the House and the Senate, actually by a fairly significant margin in both bodies, was also read by a subcommittee that met over the course of the summer of 2014. Actually, member, chair of the subcommittee, the former rep, I see sitting behind us. I don't know if you guys speak or not. I guess the first thing I want to say is you're talking about speech, the polling place, and I'm certainly a proponent of free speech as there is, but the polling place is actually a secure environment where people can securely cast a secret ballot and have it be counted confidentially. So it's not actually, the speech is actually supposed to happen outside the polling place, and you have a couple of bills coming up which deal with that. So this is, you're in the polling booth, you're just supposed to decide how to vote and fill out the ballot, and so this isn't really the place to tell people how you're going to vote. We did this is an idea was planted in my head by the Secretary of the State's office, has been looking into it, and they felt it needed to be updated because the existing law dated back to the 19th century, and it's become much easier to publish a ballot. We've all become our own publishers, so that's so I think we thought we were just updating the law, and actually the Election Law Committee in 2014, actually, there's a bipartisan consensus in favor of it. Actually, even in January 2014, went through on the consent calendar and ended up just being pulled off consent, so it became a lot more controversial than anybody expected. So it was pulled off consent. It was actually the very last bill we did in 2014 bill that we did in the 2015 session. So I think the concerns in it are still valid. I think maybe it could have been drawn more narrowly than it was, but I think we wanted to make sure that we did get a lot of. We wanted to make sure that like this practice of publishing pictures of your ballot was prohibited without getting a lot of technicalities about exactly when they posted it. There's some thought that, well, maybe it's okay if you post it after you cast the ballot, so then they have to prove did the person do it in the polling booth, and then there's also concern about whether it's actually, somebody's actually threatening or coercing or paying to do it. And I thought if you made this, if you made this illegal, that prevents such a scheme from that makes it hard for such a scheme to even be carried out. So and of course, this problem, anytime you create a new bill with a criminal penalty, even a minimal one like a violation here, you tell people they can't do something, they want to do it. So there wasn't really, there's been some incidents before this bill was passed, but not a large number. Afterwards, far from being naive young people who are enthusiastic about voting for the first time, it was primarily people, middle-aged people my age or older who were making a political point who posted them. One thing I was attacked in the court decision, and perhaps I shouldn't have done it. In retrospect, I shouldn't have done this, but that's the court decision. I did file a election law complaint against one individual, an attorney named Brandon Ross, who was one of the several people who posted the ballot selfie, and I think I was attacked for that. And the reason I picked him was partially because I thought he was making a test case out of it. He was also actually using it for a fundraising scheme. He posted the ballot selfie on a Indiegogo page to raise money for his defense, which I thought was a little questionable. But so perhaps I shouldn't have singled that individual, because I knew of a number of others I didn't want to harass. Some of them were members of this body, some of them were people I knew. One of them was a man in Newmarket who wrote my name in for every office on the ballot. Even though he lived in Newmarket and I lived in Durham, there were still several that I was eligible for. So he voted for me for executive council, Congress, and a couple of other offices. I could have actually governor too. So I thought that was almost flattering in some ways. Anyway,
So would you be in support of this bill if it was for electioneering?
No, I think we opposed this bill. I respectfully think the district court judge made the wrong decision. I don't support what the appeals appellate court did either, and I'm waiting to see what the Supreme Court did. Obviously, I respect whatever decision the Supreme Court did, and I'm not losing that much sleep over this. Is not exactly the most heinous crime around, so that's
All right.
Sitting here, a larger point, talking about proof. We should probably remember there'll be other bills coming for you, which people will allege things that they have no proof for, so which have even less proof for this one, and also voter suppression. So make sure. I think so. From that point, I don't think this bill's a voter suppression bill, but I certainly urge you not to pass any future voter suppression bills, which may come before you. I think you will have some, but.
Thank you, Representative. Do committee members have any questions for the representative?
Sure.
Representative Harrington.
Thank you, Madam Chair. Representative, maybe you could help me with this. I'm looking at the language as the bill exists today, which is the lined out portion.
Yeah.
It says this prohibition shall include taking a digital image or photograph of his or her marked ballot and distributing. And the key here is and distributing. So apparently if I go into the polling booth and I take a picture, that's okay, as long as I don't distribute it to anybody.
Yeah. Well, nobody would know if you didn't distribute it, but that's...
So let my scenario go. So I go in, I take a picture on my cell phone, and I do not distribute that, and then I walk outside and tell everybody how I voted. How is that any different than if I simply distribute the picture, rather than do it verbally?
it's a subtle difference, but you're not using the picture as proof. And of course, the picture is not absolute proof anyway, because you can then mark up a ballot and then tell the moderator you spoiled the ballot and cast a different one anyway. I mean, we can get all kinds of nitpicking about it, but it's certainly I think there's a difference between taking the picture and not showing the people, and taking the picture and posting it on your Facebook page or showing it to them. So I think that's a significant difference, even though it's not a big one.
But as you just alluded, I could create a ballot that nobody could tell the difference of between the real one and the phony one, and mark it any way I saw fit, or took a picture of that, and I could pass that on the internet and just tell people it's not the real ballot.
Thank you. Thank you for the question and the comment on that. Are there any other questions from committee members on this?
As a former member of the committee, we'll point out the new ones. There is an executive session coming up where you can obviously discuss a lot of that stuff amongst yourselves.
Thank you. And the last speaker I have signed up for this bill, House Bill 249, is Deputy Secretary of State David Scanlon.
Thank you, Madam Chair, members of the committee. I'm David Scanlon, Deputy Secretary of State, and I'll try and be brief because I know you have a couple more hearings coming up. I don't believe that any of the individuals that you heard testify in this bill would have any problem telling somebody else their opinion. And if somebody asked them to do something that they did not want to do, I don't think anybody that you heard prior to me would have any trouble saying, no, I'm not going to do that. But what we're talking about here is a person's most basic fundamental right. It's the right to vote. It's the right to vote their conscience and to keep that a secret if they want to. Contrary to the individuals that you heard before me, there are individuals in this world that will succumb to peer pressure every single time. They can't say no. If somebody asks them to do something, they're going to do it. And those are the people that we're trying to protect. Yes, everybody has a right to free speech. And I would stand there with everyone saying that that's a right that everyone should have. But when it comes to voting, the right to conscience and the right to vote in private and secret without any pressure being placed on that person to do anything other than what they want to do is the way it should be. That's why we believe that the two federal court decisions that have been rendered so far are wrong. There are constitutional attorneys around the country that agree with us. There are constitutional attorneys that have taken sides on both sides of this case. It's not an easy question to answer, but it is one that we believe should go through the process before we decide what the next step is going to be in terms of what our law should look like. So I would ask the committee to oppose this bill until the court does either decide to take the case up, and we certainly hope that they do. This is an important subject not only to the state of New Hampshire, but around the country. And there are a lot of states that are looking at what happens here in New Hampshire before they decide what to do in their own state. Before I take questions, Madam Chair, I would say that this bill does not completely repeal what was done 2 years ago when this was passed. When the bill was changed in the first place, the penalty of showing your ballot prior to voting was a misdemeanor. And when the ballot selfie bill passed, the law was changed to a violation. And I would say that if this bill is going to be completely repealed, let's do it all the way and also restore the misdemeanor penalty for showing your ballot prior to casting it. And with that, I would be happy to answer any questions.
Thank you, Representative Cody.
It just was answered, Madam Chair. Thank you.
Thank you. Other questions from committee members? Representative Gay.
Thank you, Madam Chair. Thank you for taking my question. What cases can you cite where this pressuring, which I certainly concede can certainly happen if you work for someone, if you have to be employed by someone who desperately wants you to vote the way they want you to vote and you don't want to, I can see that puts the person in a very bad position. If this person says, let's see how you voted, show me, prove it. So what cases can you cite where this has happened and somebody was free enough later to say this guy pressured me and I had to do it?
we could go back to the 1800s, but I don't want to give you a history lesson. When vote buying and intimidation was rampant, it was a serious problem, and that led to reforms that basically was the secret ballot printed by the state, and that everybody was to vote in private. And that they could not show their ballot before it was placed in the ballot box. And once it was in the ballot box, the voter no longer had access to it anyway. So that law was incredibly successful because there have been no problems during that 100+ years before the advent of technology came. And that is what is, raising the issue again, and it's taking some states to look at this preemptively. You asked for a specific example. I don't have too many, but there is one that strikes me from this last election, which is a good example of this. Kelly Ayotte was asked who she was going to vote for president, and she said that she was going to write in the name of Pence, the vice presidential nominee. And then the next question was asked her, would you be willing to take a selfie and show it to us? And her response was, yeah, sure. Well, that's the type of thing that I think we're trying to prevent. At that point, she's boxed in. She couldn't change her mind, without suffering some type of embarrassment or accusation of lying or not keeping her word. And that's one example, and I'm sure that you could think of many other scenarios that would take place out there that we're trying to correct.
Thank you. Representative Pearson.
Thank you, Madam Chair. Would the old statute have been just as sufficient at prosecuting Kelly Ayotte if she had agreed to take a ballot selfie?
Can you clarify your question? When
Yeah,
you say
I realized that didn't come out really well. So say we didn't have this ballot selfie law on the books, would the old RSA have been sufficient at stopping Kelly Ayotte from potentially selling her vote to the media?
I don't believe so, because the law said that you cannot show how you are about to vote. But if she showed it after the fact, then I don't think there would have been anything to prevent that.
Okay.
Thank you. Other questions from committee members? Seeing none, I have one more card that's been passed in for House Bill 249, Representative McGuire.
Former. Thank you, Madam Chair, members of the committee. I'm a former representative.
So that's
I didn't run for
sorry.
re-election.
You didn't write it down, I just threw it in there.
Thank you very much. But what I am is, I represent the New Hampshire Liberty Alliance. I'm the political director. I wasn't going to testify because a lot of these points were made. We're in favor of the bill. But Secretary Scanlon said something that I strongly disagree with, which is, he said, let's wait and let's see what the courts do. And there's a tendency when there's constitutional questions on legislation to say, let's leave that to the court. The Constitution's kind of their bailiwick. And that is not so. It is definitely the case that the legislative branch, the executive branch, and the judicial branch are all under oath to follow the Constitution and consider it and so on. So if you, as representatives, think like I do that this is unconstitutional, that the law is unconstitutional, then it's up to you to change it, regardless of whether the court itself ultimately comes to that decision or not.
Thank you.
Thank you.
Questions for former representative? Seeing none. I have a card that's just been passed to me by somebody named, from John Lewicki.
John Lewicki, yes. Thank you, Madam Chairman.
Good morning. Our briefly former member of the election.
Okay, well, I am a present member, but I'm speaking only for myself. I believe that the law as it exists is clearly unenforceable and farcical in the present day.
Do I have permission to check off I oppose the bill on the card?
No, he supports no. No, I actually am in favor of the bill.
Okay.
But what I will say, which people have said, there has been no vote fraud, no buying of votes for over 100 years. I have twice been solicited by individuals from our neighbor to the south to vote in a particular way in exchange for them voting essentially the way that I would like. This is not, and this is all once in the past election and once several years ago. And the mechanism to do this kind of vote swapping would be the ballot selfie. And so despite the fact that we can't stop it, it does exist in the present day. I have been solicited twice. That's all I have to say.
Thank you, Representative. Questions from the representative? I'm seeing none. Thank you for coming. That is what I have as the last speaker for House Bill 249. I will note for members of the public and other people here that there are sign-in sheets. If you wish to let us know your opinion without actually speaking, you can sign your name and your position as to the bill. Having said that, I'm going to close the hearing on Bill 249 and open the hearing on...
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.